Good morning to those of you who are joining us already. We're just going to give people a minute or two here to get signed on before we get started. We do have a pretty big group signed up for today's session, so we'll begin in just a moment. All right, well, I'm just going to do a quick intro before we kick off here. So thank you for joining us for today's webinar, Illinois Paid Leave for All Workers Act with Lorna Geiler. Before I hand over to Lorna, just a few quick things. You will be receiving, my apologies, a follow-up email later today with a recording of this session. So if there's someone on your team you need to share it with, or you need to go back and listen to it again for some guidance, you will have access to do that as well. We do have some community partners who have assisted with promotion on today's session, so I'm going to include links to all of their websites in that follow-up email as well, so you can check out the resources that they have to offer. And you are also welcome to ask questions. We just ask that you submit those via the chat box. This is set up as a webinar, so we cannot see or hear you, but just drop those in the chat and we will make sure to get them answered before we close out today's session. And then, like I said, that follow-up email will go out later today, so please be on the lookout for that. Okay, I'll go ahead and hand it over to Lorna and we can get started. Oh, you're muted, Lorna.
You know, it makes me wonder if my husband's come in and pushed the button because he'd like to meet me regularly, right? Sorry about that. Good morning, everybody. Lorna Geiler here. For those of you who attended this like early, maybe even this time last year, welcome back. Maybe it's gotten a little more well-defined. The statute's become a little more well-defined. Maybe it hasn't. There's still lots of questions. Please submit any questions you guys have. We'll do our best to answer them. And we'll run through this presentation and give you the information that we have available. I say that because with any new statutes, like a new make of a car or something, there's bugs that are going to have to be worked out. So okay, so sorry guys, my clicker is faster than it was resting for a minute there. All right, so the Illinois Paid Leave for All Workers Act. You will hear me call that PLAWA, P-L-A-W-A, Paid Leave for All Workers Act. So I call that PLAWA. Some people call it PLA leave. Some people call it PTO. Everybody's got their thing. But this is the statute that was signed in last year, went into effect 1/1 of this year. You can see if you're a legal researcher kind of person that likes to actually read the statute, there's the statutory citation, and I'm sure that this slideshow is available to you folks post webinar, so feel free to look up the statute and read it for yourself. But basically, let's talk about what the act requires. It requires virtually every Illinois employer to provide covered employees up to 40 hours of paid leave to be used for any purpose. So I said virtually every. There are a few employers that it doesn't apply to, and we'll talk about that in a minute. And I said, and the slide, and I said covered employees. So that leads you to believe there are some employees that are covered and some who are not covered, and we will talk about that as well. So Illinois is on the cutting edge of requiring employers to provide paid time off. We're right there after Nevada and Maine. There are other states that are in the queue, but we are third. So because this statute is going to into effect on January 1, or went into effect on January 1, 2024, it's a little bit different. Typically, we say things like, when an employee becomes employed, they immediately begin accruing. Well, that will be true for all employees hired after 1/1 of 24. That is true. For those employees that are current, that are already on our payroll, they began accruing PLAWA leave, if you are using an accrual basis, on January 1st. So what does, so for this, I call this the transition year. It's going to be a little bit off. It's going to be a little bit weird. It's going to be the transition year. So for existing employees, statutorily, they began accruing PLAWA leave on 1/1/24. If an employee, if we are using the accrual method, then those employees, existing employees who began on 1/1/24, can start taking their leave on March 31st, 90 days after they accrue it. Prospectively, the way you'll look at this is employees begin accruing PLAWA leave upon employment and can begin taking PLAWA leave on the 91st day of their employment, if you're going to do it on an accrual basis. So it becomes easier once you are just dealing with new employees as far as implementing this benefit. So what does it do? Employees earn an hour for every 40 worked. That includes overtime hours. So if you've got employees that are working 50 hours a week, then they're going to accrue more than an hour per week of PLAWA leave. They're going to accrue an hour plus. For a 40-hour-a-week employee, it's an hour a week. For a 37.5-hour-a-week employee, it's not quite an hour. What do you do with those folks that don't record their hours, even though for a different reason, everybody should be recording their hours? What do you do with those folks that are salaried exempt employees? They are presumed to work 40 hours in a week. So in their regular work week, when they're not taking time off or whatever. So how do you track this? Well, you can track it like you track probably the accrual of regular paid time off benefits, vacation, PTO, sick leave, whatever it is you have. It is probably done on a length of service or hours worked basis. So this just falls within that. Who's an employer? I told you we'd get to this. Who's an employer? Pretty much everybody, except, interestingly enough, school districts and park districts. So K-12, that's a school district, not U of I, not Parkland. K-12 is a school district. It doesn't apply to them, and it doesn't apply to the Champaign Park District. I'm sorry, school district. Yeah, I said school districts. It doesn't apply to Champaign Park District, the Urbana Park District, the Clark County Park District. It doesn't apply to those folks. But the rest of us, so the University of Illinois, the city of Champaign, Meyer, Capel, applies to all of us. It also, I told you, covered employees. So what is an employee? It's somebody who works for you, not an independent contractor, but for other reasons. Recall, guys, remember there's a new statutory guidance on what is an independent contractor. Remember that just came from the Department of Labor. There's a new test. They're tightening it up. They're preventing us from calling people, even more people, independent contractors. So anybody who provides work for us is basically an employee, unless it is particularly unique, like in an independent contractor situation. Full-timers, part-timers, seasonals, all those folks are employees for PLAWA leave. It doesn't apply to these employees. So there's a list of employees on this slide or a list of categories of employees on this slide that are exempted out from PLAWA. So the Federal Railroad Unemployment Insurance Act defines employees. If you're covered by that, you're not covered by PLAWA. Temporary college or university student employees, that is basically student employees. Okay, so that is the student employee who has a work study kind of thing. Certain short-term employees of institutions of higher learning, I didn't flush that out because I figure U of I is probably dealing with this on their own, and that's our only local, anyway, institution of higher learning. Employees working in the construction industry who are covered by a collective bargaining agreement. Okay, so just because somebody's working in the construction industry doesn't make them exempted out from PLAWA. If they're covered by a union contract, then they're exempt from PLAWA. Now, again, it's those in the construction industry who are covered by a collective bargaining agreement. So not just because you're a member of a union. So let's say you're not in the construction industry, but the Champaign County, city of Champaign, both those folks have unions who are covered by collective bargaining agreements. the Paid Leave for All Workers Act applies to those employees. However, a ready-mix concrete company, mechanical construction company, electrical company who has a collective bargaining agreement with some of its employees. So the electricians are under a collective bargaining agreement. The electricians for that client or for that company, sorry, are not covered by the PLAWA, but the non-union employees are indeed covered by PLAWA. So that's an important distinction to understand. And it specifically includes folks moving construction. So Teamsters sometimes are considered in or out of the construction trades, depending on what they're doing. So if they're delivering stuff and dropping it off at a job site, sometimes that's considered not construction work. The statute specifically saying, hey, we're including that in this exemption here. And then finally, employees who are covered by a bona fide collective bargaining agreement with an employer who provides services nationally and internationally of delivery pick. Does this sound like anybody? Does this sound like UPS to you? So UPS is exempted out of this. So here's the statute. An employee who works in Illinois, see how that's emphasized here, is entitled to earn and use up to 40 hours of paid leave during a 12-month period on a prorated number of hours of paid leave under the provisions of subsection B. Okay, what does that mean? It means an employee who works in Illinois. So we have lots of employers now who have employees working remotely who are working in California, Indiana, Europe, wherever they may be. They're not working in Illinois. Okay. If that being said, if you look at the Department of Labor FAQs on this, how does this work? How does this work? Because we're all such a diverse workplace population. The Department of Labor is going to find an Illinois workplace protections, including PLAWA, applies to employees who perform their work in Illinois for a company that does business in Illinois. Okay, so let's say Meyer, Capel, a law firm. You know, we've got a couple of Illinois offices. Let's say that we open an Indiana office and we hire Indiana lawyers to staff that office. It's kind of easier with us because of our licenses. I have an Illinois license. I have to get permission to practice in Indiana because I have not taken Indiana's bar. I have not passed their character and fitness. I haven't done any of that stuff. So I have to get permission to practice in Indiana. So my work is done in Illinois. The same would be true for my colleague who is now staffing the Meyer Capel office in Indiana. She has an Illinois license, let's say, or I'm sorry, an Indiana license, let's say. So she practices primarily in Indiana. If she's coming over the line, it's to perform work just for a little bit here, for a particular case here. Does it apply to her? Well, no, not for her Indiana work. But for that Illinois work, she accrues PLAWA leave. Record keeping nightmare. Of course, Department of Labor, even though they've known this is coming for a year, they've known everybody wants to know, they're going to provide more information. They're going to provide better rulemaking. What they're going to do is wait and see what happens and how everybody freaks out and what the issues are, and they're going to try and patch it. So stay tuned for that. So we talked about accrual. I said employees begin to accrue. You can do this two ways. You can do it as an accrual, which is typically how folks do benefits. They accrue. I accrue vacation based on my years of service. So I earn it over time. That's an accrual method. That's the most common method of earning paid time off. And this is another form of paid time off. You can also front load it. So again, let's take 2024 out of the mix because it's that transition year. You could say, okay, our company is going to do this on a calendar year. So, you know, nobody's actually hired on January 1st of a year. So for those employees that are hired on, let's say, begin work on July 1st, they're going to earn or they're going to be front loaded half a year of PLAWA leave, for example, if you're going to front load. And then come January 1, 2025, they're on the same calendar as the rest of us, and we're going to front load it. What's that mean? Well, it means exactly what you think. We're going to put 40 hours in the bank for employees beginning 1/1/24, 25, 26, or you don't have to put it on a calendar year. You can say, beginning on your first date of employment, we're going to put 40 hours in the bank. So it could be July 1 that one employee is going to get their 40 hours, and May 12 is somebody else going to get their 40 hours. It just depends. So that's front loading. So what's accrual is you earn it an hour per 40 hours worked. So what's the benefit of one versus the other? Well, I'm not going to get into the accounting benefits as far as record keeping, trying to track stuff. I'm not going to get into that. I'm going to point out a few things. PLAWA leave, you don't have to pay out if an employee leaves. So unlike accrued but unused vacation, don't have to pay PLAWA out. So if you have front-loaded PLAWA and somebody has taken their full 40 hours, but had you been under an accrual method, would have only earned 20, arguably they owe you 20 back. We all know that that's difficult, if not impossible, to collect. So that's a disadvantage of front loading. An advantage of front loading is you don't have to let people carry it over. No carryover with front loading, because the thinking behind this statute was, hey, everybody needs, in essence, a week of time off to deal with stuff during the course of a year. If you are front loading it, you're giving folks that week at the beginning of the year so they can use it or lose it that year. And you're going to front load it for the next year. You're not giving them more than a week. You're just giving them a week. So if you front load, done. And let's say we use the calendar year, front load on January 1. It's gone on January 1 of the next year if you haven't used it. When you use an accrual method, employees can carry over. Statutorily, employees can carry over up to 40 hours into the next year. Now, this makes no sense. Well, it makes some sense, but makes no sense. Let me say that. Because an employee can only use 40 hours of PLAWA leave in a year. You can limit them. So let's say I'm that person who has worked this year and I didn't use my PLAWA leave. And let's even say Meyer Capel front loads it. So I was front loaded 40 hours of PLAWA leave on January 1st. And, life just got away from me. And I didn't use any leave this year. And if it was front loaded on January 1st, it's gone on December 31st. And on January 1st, 2025, it will be front loaded again. And I can take that next year. But I've lost that 40 hours from 2024. If we do it on an accrual basis, so Meyer Capel now decides we're going to do it on an accrual basis. So Lorna starts earning PLAWA leave on January 1st, and I'm a salary exempt employee. So it's presumed I work 40 hours in a week. And I can tell you that earning time off at the rate of 1 hour per 40 is sometime in September. I will have earned that 40 hours. Now, let's say again, life got away from me. I didn't remember to take any time off. December 31 comes and goes. I can carry that full 40 over. And I begin accruing the 2025 PLAWA leave. However, in 2025, I can only take 40 hours. So you think, well, that doesn't make any sense. Yep, you're right. It really doesn't make any sense. You accrue the 40 hours. You think that, well, then if I'm moving 40 hours over that I didn't take, I earned that. That's PLAWA leave. I earned it. But remember, with PLAWA, you don't earn it so that you get it paid out when you leave. So I earned it. I didn't take it. I saved it. I should be able to use it. Well, I can. But between those 2 years, I will earn 80 hours. I can only use 40 in a 12-month period. I will never catch up to that PLAWA leave. Ultimately, I will retire, die at the desk, whatever is going to happen to me. And there will still be PLAWA days in the bank. But remember, it doesn't have to be paid out. So that's one of those nonsensical things that are in this statute that I expect to be fleshed out sometime this year. So I kind of brushed over this. you're earning 1 hour for every 40 hours worked in a 12-month period, up to 40 hours. I don't think I've said that. I'm now saying that. Up to 40 hours. So like I said, if we start on 1/1, assume 40 hours a week, I'm going to earn out in September. I stop earning plowable leave at that point. Okay. You don't have to keep allowing me to accrue it. I stop earning plowable leave. But this is also important for a different reason. Lots of employers are saying, well, we give all our first-year employees a week of vacation, so we're good. We're good with PLAWA. Not quite, because those employees will earn that, assuming full-time employee, by September. So the employee that starts on January 1 will earn that in September. You're giving it to them over the course of the year through December. So you kind of have to either speed up the accrual, front load the accrual, or make sure it's all available when it's earned. So, as I said, you can use a calendar year. You can use an anniversary year. Those are general. You can use any 12-month period you want. So you could use your company's fiscal year, but those are kind of the 3 basic years that make sense for folks: calendar, fiscal, or an employee's anniversary year. You can change it. You can change that PLAWA year calculation. So if you've chosen calendar year and you think this just is not working, it's just too confusing, we need to do it on an employee's anniversary date or an employee's year. You can change it. You have to give notice. You have to calculate the PLAWA that's been earned and make it all right, so somebody's not losing any PLAWA leave. But you can do it. So you're not married to that forever. So here's where we really kind of get into. First of all, most of us offer at least a week of time off for folks in a year, which is pretty close to PLAWA leave. Not quite there, as I noted before, but pretty close to PLAWA leave. So most of us are already giving folks, and if you combine that with the sick time and the personal days and all that, we're giving people a week of paid time off in a year. We just are. What makes PLAWA different? Well, now we're requiring it. Now we're requiring it for part-timers and seasonals. So that's a big difference. But also how you use it and what an employer can require for somebody to use it becomes significant. So paid leave under the Act can be taken for anything. Done. Full stop. Anything. An employee is not required to provide you with the reason that they're taking the leave. They can't be required to provide a doctor's note, any type of school certification or whatever, an obituary. Nope, not for PLAWA leave. And they can use it prior to using any other leave. So they should, if they think about it. Okay, my vacation, I accrue it, but don't use it. I get it paid out when I leave. PLAWA, I don't. Well, I want to use that PLAWA leave first, because I'm going to lose that if I don't use it. So employees will figure that out, and it's not like hide the ball, and it's not a taking advantage thing. They should use this leave first. The disadvantage for an employee of using up all their PLAWA leave first is they don't have the flexibility that PLAWA requires. So with PLAWA, I can call in this morning and say to my secretary, who's really my boss for all practical purposes, I can call in and say, Kirsten, I'm not coming in. I'm using a day of PLAWA. Well, she can't really ask me what I'm doing. She can't really require me to bring in a doctor's note or whatever. She can't discipline me, because certainly I have lots of employers who have employees call in on Mondays. Once a month on Mondays, employees are calling in. I call that the party flu. They've had a good weekend and they need that day of rest. Yeah, that could be a PLAWA day now. So she can't ask for any of that stuff. She's got to give me the leave unless operational needs of Meyer Capel require otherwise. So I lose that flexibility if I burn those 40 hours of PLAWA leave. So in December, when I want to take Christmas Eve and the day after Christmas off to make that a longer time off, I may not be approved for that. I may be counting on my vacation to use that. And there might be a bunch of folks who want vacation the week between Christmas and New Year's, so I can't get that second day. If it was a PLAWA day, I could probably get it. But that's the employee's choice. The employer doesn't get to choose. Okay. You do have some control, minimal, but some control. you can set a reasonable minimum, but that minimum can't be anything more than 2 hours. So whether that seems reasonable to you or not, it can't be anything more than 2 hours. So you probably currently have a vacation policy that says, employees can earn vacation this way. You can take it upon this much notice if approved. And vacation has to be taken in half day, full day, whatever increments. With PLAWA leave, you can say the minimum or the increment is 2 hours. Can't be any more than that. So it gives you some control, but less than probably what you're used to. That being said, if an employee, so now let's talk about the employee who comes to work at your fast food restaurant between the hours of 11 and 1, or 11 and 12:30, or 11:30 and 1. If their shift is less than 2 hours, then the length of the leave can be in a smaller increment, like an hour and a half. Employees can use it whenever they want. Employers can require reasonable notification. Well, y'all are going to say, well, that's like our vacation policy, reasonable notification. Now, in my world, I need Kirsten to tell me, hey, Lorna, it's January, whatever today is, January 26th. I think our family's looking at going on spring break, March 24th. So I'd like to take that week off. I need to know now so that we can properly plan and stuff like that. Certainly that doesn't mean that she can't take the time off closer to time, but it's much easier to accommodate. And I think Meyer Capel's policy, but for PLAWA, would say you need to give at least a month's notice for a week or more of vacation at a time. PLAWA leave, nope. If it's foreseeable, you can require 7 days notice. Foreseeable. Okay, so then you say, okay, well, Lauren, then if it's foreseeable, they need to ask me, or I can just tell them no, right? Absolutely. And then I'm going to say to you, how are you going to find out if it's foreseeable? Well, I'm going to ask them what it's for. Nope, can't ask them what it's for. Again, another hole in the Department of Labor's process here. We can't know if it's foreseeable because we can't ask what it's for. So if it could be something so simple as my brother's coming into town. And then if it's me and I'm trying to figure out if it's foreseeable, I'm going to say to Kirsten, says, my brother's coming in town and we're going to all hang out on this day. That's great. And let's say that I'm in trial and I can't, it's going to be a real burden for her to be gone. Well, when did you know your brother was coming into trial, Kirsten? Is this poor planning on your part, or what is this? And if she tells me, well, he told me about a month ago that he was coming into town, and I could then say, hey, PLAWA leave, you can't use it. This was reasonably foreseeable. To which she could respond, yeah, but I didn't know he was going to be available on January 31st. I thought he was going to be at his in-laws. So it's now back to not foreseeable. So this 7 days notice, if it's reasonably foreseeable, good to put in your policy, good to remind employees of. Enforceability, it's kind of questionable, really is kind of questionable. Some clients have a system where they require employees to try and find their own replacement. So if you're going to call in, if you want to take the time off of your regularly scheduled shift, do a shift trade, a duty trade, whatever, to get your time covered. Don't leave that on my desk unless you're sick or in the hospital or something like that. You can't leave that on my desk. You need to work it out to provide your own coverage. Nope, not PLAWA. They cannot be required to obtain a replacement. So what do you pay them? Well, you pay them their hourly rate. Okay, so if my hourly rate's $20 an hour and I'm taking 2 hours off, you're paying me 40 hours or $40 for those 2 hours. Okay, you with me? And that would be true, whatever the rate is at the time, whatever your rate is at the time you take the leave, that's the rate. Not necessarily the time you earn it. The rate at the time you earn it's the time when you take it. So that's the rate. So what about somebody that's exempt? Or somebody that, let's do this. Somebody who earns commission. Okay. So they have this fluctuating wage. For those folks that you can't otherwise reasonably determine their hourly rate, it's minimum wage. So you have to pay at least minimum wage. So if someone's purely commission, you can pay them for their plow leave minimum wage. Because quite frankly, if they weren't working, their pay would be zero. I mean, it is what it is. It's not going to be impacted, yes or no. So it becomes a minimum wage. For salaried folks, you can actually, if they've got a regular salary, you can actually determine an hourly rate. You can say, you get paid, I have to do things very simply. You get paid $4,000 for 40 hours. Therefore, your hourly rate is $40 an hour. Okay, I think I did that right. So that's what you can do, because we expect you to work. We expect this to be a full-time job. We're presuming you work 40. You're earning plowable leave at the rate of 40 hours, assuming you work 40 hours in a week. Therefore, let's take your your annual salary divided by 26. That's your weekly rate. Let's divide that by 40. Okay, now we have an hourly rate. You see? You can figure out what their hourly rate is if they take it in hour increments. You can figure out daily rates, same way. So we've talked about this. It begins to accrue on January 1, 2024, or your first date of employment, whichever is later. So eventually we're just going to, next year it's going to begins to accrue on your, well, actually right now. So right now, employees hired now, it begins to accrue on their first date of employment. January 1, 2024 is already stale. Employees shall be entitled to use their paid leave within 90 days from commencement of their employment, or on April 1st, this too will be stale, or March 31st, 2024. If you use the accrual method, they're only entitled to use what they've earned. So, it may be a day, but they're entitled to use what they've earned. If you use the front-loaded method, they would be entitled to use their full 40, either on March 31 or the 91st day of their employment. This is where people need to understand what happens when you don't separate plow leave from your regular paid time off. So as I said earlier, probably everybody on this call already has paid time off that either one bucket individually or more than one bucket cobbled together comply with plow. Gives people a sufficient number of days off anyway. Okay, but if you leave it in those buckets, it becomes, as PTO, take sick leave out of this, but as PTO, personal days, vacation, PTO, all names for basically the same thing. If you leave it there and you loosen up how it's used and things like that to make it comply with the statute, as we've already talked about, then when that employee leaves, it is accrued but unused. Now, that's not necessarily a problem because you're not really adding anything to their paid time off. If you were adding 40 hours to their paid time off to comply with PLAWA and putting it in a PTO bank, then it really would mean something. But as we said, on December 31st, 2023, if an employee had paid time off in their paid time off account that they had accrued but not used and quit, you, the employer, would have to pay that out. If you're going to still use that bank of paid time off to cover your PLAWA obligation, yes, you will have to pay it out when an employee leaves, but excuse me, but has not used it all. And you technically don't have to play PLAWA out like that. But what you've really done is taken your paid PTO and used it to comply with the statute. So money out, you're not hurt, if you guys track that. We got to tell people about this. Everybody was thinking back when this was passed, oh my gosh, I'm gonna get another week's vacation. I'm so excited about that. My employer's gonna have to give me another week's vacation, which is never what this statute said. So there is confusion. It's getting better and better as far as folks understanding, but you got to provide people written notice of your paid leave policy. You just do. Now, sometimes you can do that in an employee handbook. Sometimes you do that with a policy. Sometimes you do that with an offer letter, but you got to provide that. You also, employees must be notified within 5 days of any calendar change too, or change to notification requirements. So let's say you haven't required 7 days notice if it's reasonably foreseeable, and you're well, you got to give people at least basically a week of notice so that they know that's going into play. Or, hey, we're going to change this from that calendar year thing is not working for us. We're going to do it on anniversary dates. You got to give folks notice. You also have to post it with all the other wage and hour and labor law postings. So think of that wall in your break room that you have, or that bulletin board, or the back of that door, where you have that poster that has, minimum wage, and it has ocean information and EEO information. Now this. And you can get it, just like you can get those other posters, you can get it from the Department of Labor, and you just need to post it or include it. So there you have it. And again, you guys will get this. I believe you guys get this presentation. So the link is right there for you to get that poster. Document retention. So we're the mechanics of being an employer. How long do you have to keep records? So you're tracking PLAWA, you're treating those 7 days, those 40 hours, I'm sorry, 5 days, those 40 hours of PLAWA leave, you're tracking that differently because you really do want to limit people's short notice ability and things like that. Well, you need to keep those records, and you need to keep those records for at least 3 years after the leave's been accrued and taken. So it's not uncommon for us to purge employee files and this kind of stuff after an employee leaves. So you may well keep it more than 3 years if you keep it with employee type information as opposed to financial type information. But at least 3 years from the applicable year. So the 2024 stuff, don't get rid of that until 2028 at the earliest. So no retaliation under the statute. Just like any other employment statute, no retaliation. You can't threaten or take away or cause any adverse action to an employee because they exercise their rights under PLAWA. So, I was thinking about moving you to shift supervisor, but man, I just can't count on you to be here regularly. You give short notice. No, that could be retaliation. Or 2, if an employee opposes practices which the employee believes violates the act, it's got to be a good faith belief. Right now, of course, we have all these lots of folks thinking they're entitled to things that they're not entitled to. But let's say you have an employee who wants to take PLAWA leave, and you say, okay, well, in your probing to find out if it was reasonably foreseeable, you say, what are you going to do? And the employee pushes back and says, I don't think I have to tell you what I'm going to do. And you say, well, I need to know if it was foreseeable. And the employee says, it wasn't. Well, that's going to irritate me, quite frankly. But I can't use that as the basis, certainly for discipline, but I actually can't use that for the basis of any decision, a promotion, an assignment, things like that. I can't use that because they're opposing a practice they believe in and, quite frankly, is a violation of the act. Or, as with other statutes, they support someone else's exercise of those rights. You also can't consider their use of paid leave for, here it is, evaluations, promotions, discipline. So I liken this to FMLA. FMLA is a major inconvenience for us. We have jobs because we need those jobs done. So they're not superfluous. They're not just there. We actually need people to do these jobs, and 12 weeks off is a long time for us to limp along without someone. So it's inconvenient. It's a problem, and that isn't even touching, the intermittent leave off for like a migraine headache or something where you just can't predict when someone's going to be off, and they're consistently off, and they never run out of FMLA because they never take a full 12 weeks and those kinds of things. So those can't be considered. Just treat PLAWA leave like FMLA. It's a nope, can't take that into account when I'm making this decision about them. When I'm saying, okay, here's our evaluation form. You scored 5 on everything except for attendance. You scored 2 on that. Well, if the 2 is the score on that because of PLAWA in whole or in part, that 2's bad. And if that 2 is the basis for an evaluation, it's bad and it can't be considered, or it can't be a part of the evaluation. Even worse if that 2 brings my percent down of my annual increase. You see? So understand that. So I've already said this. You probably have a policy that already provides the time off that's required by the PLAWA. So you can put PLAWA leave within your policy. If you're going to keep them separate or you're going to track them separate, the employee gets to choose, am I using vacation? Am I using PLAWA? When does this matter? So let's say I'm calling Kirsten again today saying, yeah, it's Friday. I'm just not coming in. I'm not coming in today. Well, if vacation, Kirsten's question to me could be, are you using PLAWA or are you using vacation? The reason is vacation, employers have a lot more control over. Well, why are you going to be gone? I'm not going to give you a vacation day until you tell me why you're going to be gone and why you're calling me at the last minute. If I say I'm going to use PLAWA, she can't ask those questions. So I get to pick as long as I have both kinds available, but you can make me pick. And quite frankly, if you're going to track them separately, you should make me pick because you need to record it. Enforcement. It's a Department of Labor enforcement. And so it's not the Department of Human Rights, it's the Department of Labor. So think wages and hours, think unpaid vacation. When employees claim I didn't get all my vacation paid out to me when I left the employment, or you still owe me commission when I left my employment with you, those kinds of things. That agency is the agency who's going to be enforcing this statute. If we violate the policy, we violate the statute, it's a $2,500 penalty. Okay, it's $2,500 penalty for each offense. So let's say we've applied our policy. Our policy's bad. We've applied our policy and we've got 200 employees. The potential penalties are significant. And let's say each employee, they've asked for PLAWA time at least 5 times and we violated it every time. The potential penalties are very significant. What are that's to the Department of Labor. So that penalty, that goes to the Department of Labor. So getting that waived is not simple. Now getting it negotiated down can happen, but getting it waived, that's how the Department of Labor pays their bills, I think, sometimes. What does the employee get for bringing the complaint other than a ha-ha, I told you so, if they were right? Well, if we didn't pay them for time off they should have been paid for, they get the underpayment and a penalty of at least $500. Okay. So employees are going to get $500 basically, because the enforcement of this is going to probably be, you didn't give it to me when you should have given it to me. So I worked instead of taking the time off. That's going to be the more likely problem. That's going to be a $500 penalty. But if they hire a lawyer, it's going to be the $500 penalty plus their attorney's fees, which are by definition going to be more than that. So understand that the department has built in some penalties here, even if you look at it and think no harm, no foul. You worked, you got paid, we're all good here. Nope, there will be a penalty. That's it. If anybody has questions, I assume, well, I see a chat here, but I'm sad. Jordan, can you help, please?
Yep, I'm here. Yeah, so I'm going to go through all of the questions. Some of them we may have covered, but I just want to make sure we get everything answered.
Sure.
The first one says that their main question is if this applies to interns that receive a stipend.
Interns that receive a stipend?
Mm-hmm. Correct.
Yes, I believe it does.
Okay.
Unless like it's a university kind of situation where the university is, that otherwise exempt employee, I believe it does. So like an intern works for McClure Financial and doesn't get paid or gets paid only a flat amount, not an hourly rate. Yes, I believe it does.
Okay, perfect. The next one says, does this law apply to commission only employees? And if so, how do you calculate vacation time?
Okay, so I don't think it's vacation time. I think it's PLAWA. I don't care how you calculate vacation time. I'm talking about PLAWA. So the way I think the question is, how do you pay someone for time off if they are commission only? I think that's the question, and because their paycheck's going to vary month to month. So you can assign to them the hourly rate of minimum wage or anything more than that and pay them that way.
Okay. The next one goes back to schools being exempt. What about private schools?
They are not exempt.
All right. The next one is, if we are using an accrual method for this time, do we have to pay out the balance earned by the employee if they're terminated?
You do not have to pay accrued but unused at all. So
Okay.
accrual or front loading, you do not have to pay it out at all.
Perfect. And then the next one says, I assume that if we are paying bartenders $10 per hour, sub minimum, we must pay them $14 an hour for their time off and not the average of pay with tips of $30 per hour.
You have to, for people that are paid that's effectively commission, it's the minimum wage or better. So you can choose to pay $30 an hour, but you can also choose to use the minimum wage.
Okay. And then right now we have two more. The next one says, if we have 3 days front loaded PTO already, if I understand it right, we can only provide 16 hours more earned PTO. Is that right?
So you can provide as much PTO as you want to provide. I think the question maybe is, how much do you have to? So you have, if you're going to front load it all, for a full-time employee, you have to front load 40 hours. Okay. If it's a part-time employee and they have a regular schedule, figure it out. What would an hour for every 40 hours worked? Front load that. If it's a flexible schedule, do your best guess, front load that, and then evaluate it maybe at 90 days, 120 days, 180 days.
Okay. To kind of build off that one, just because this may come up. So if they already provide, before this even came into effect, if they already provide 3 days, do they still then have to front load the 40 hours, or it's just 16 okay? Is what I think they're asking.
16 additional hours?
To then get to that 40, because they were already providing 24.
Sure, you can use your current paid time off as PLAWA leave. You can use that. So if you currently, your policy is, hey, we're going to give everybody 3 days, 24 hours of paid time off in a year, and we're going to front load it the first day of your employment or January 1, whatever it is. You can use that as PLAWA leave. You got to supplement it. You need a couple more days, or at least enough to get 40 in for every 1 hour worked. But yes.
And then the last one we have right now says, do we need to have this paid leave and vacation time separate?
You don't have to, but you can have it separate. The advantage of having it separate is PLAWA leave, you don't have to pay out if it's accrued but unused at separation. Vacation, you do if it's accrued but unused at separation. The advantage of combining, and another disadvantage, another advantage of keeping them separate is if you have notice requirements and increment of time off requirements greater than 2 hours, you can still enforce that with your paid time off. PLAWA, remember, you really can't effectively require notice. You can require 7 days if it's reasonably foreseeable. And the maximum limit on the amount you can require employees to use is 2 hours or their shift, whichever is greater. Those are the advantages to keeping them separate. The advantage to keep putting them together is it's much easier to track.
All right. That's all the questions we have submitted right now. I do want to remind everyone, because I know some people jumped on after we had already started, you will get the recording of this along with the PDF version of the PowerPoint, so you can go back and listen to the answers to those again. You can re-listen to anything that Lorna explained. Like I said, if you need to share it with someone on your team that this pertains to more or something like that, please feel free as well. And that email will go out later today. But it does look like we are all caught up with questions. So I want to thank everyone for joining us, and thank you so much, Lorna, for presenting today.
My pleasure. Thanks, guys. Call me if you need me.
Thank you, everybody. Bye-bye.